Starting a business involves making many decisions. One of them is deciding on its form of organization. The alternatives you have to choose from include sole proprietorship, partnership, corporation, or limited liability company. In each case, you should weigh the pros and cons of each type to select the form that best suits your business. Forming a sole proprietorship is the easiest and least costly way to start a business. In many cases, the only step required is to apply for a fictitious name, or DBA, that allows you to open a business banking account. In the state of Florida, the application fee for a fictitious name is only $50. The main disadvantage to a sole proprietorship is the owner is personally liable for claims against the business. For example, if a disgruntled customer sued you successfully, you could possibly lose your personal assets like your house. Another alternative available to you is a business partnership. This is created when two or more persons agree to start a business. There are two principal types of partnerships, general and limited. A general partnership is the easiest type to form. The required steps are filing a registration form and a statement of authority. The filing fee in Florida is only $50. One additional step you may want to take when forming a general partnership is executing a partnership agreement. The biggest disadvantage of this form is that a general partner is liable for the losses of the whole business. A limited partnership is similar to the general partnership with one major exception. Partners are only liable to the extent of their individual investment in the enterprise. The company might fold due to your partner's poor decisions, but you wouldn't be responsible for losses above your initial investment. A limited partnership is a bit more complicated to start than a general partnership. In addition to registering your trade name to protect it, you must file a certificate of limited partnership. In Florida, the filing cost is $1,000. Overall, the biggest advantage of a partnership is it can be relatively simple to set up. On the downside, the largest disadvantage is that with a general partnership, you are personally liable for more than half of the business's losses, and you are also responsible for your partner's business decisions, even if they are bad ones. As in the case of the sole proprietorship, with a partnership, you and your partner are not protected from liability related to suits filed against the business. A third option you have for your business is a corporation. A corporation is an entity that is separate from the people who own it. Shareholders govern the corporation indirectly by electing people to manage it. Forming a corporation is a bit complicated, and you may want to retain an attorney if you choose to organize your business this way. Once formed, a corporation must comply with several procedures like holding regular board of director and shareholder meetings, as well as keeping records of each meeting. In the state of Florida, the initial filing fee for a corporation is only $70. When you consider the pros and cons of a corporation, the first is that it is a separate legal entity from the individuals owning it. This means that if someone sues the corporation, shareholders are only liable for the claim up to the amount of investment they made. The drawback to this business form is it may be more complicated and more expensive to maintain. There are ongoing regulations to abide by and fees to pay. When it comes to forming a corporation, there are several different types to choose from with various advantages and drawbacks. The most common forms are the C and S corporation. The C corporation is the most common for America's largest companies. The letter C simply refers to a subchapter of the IRS code. The separate nature of the C corporation creates advantages and disadvantages. Since the C corporation is separate from its owners, also known as shareholders, the owners may be taxed twice for any profits. That is, the corporation pays taxes on its profits, and when it distributes the profits to the shareholders in the form of dividends, the shareholders then must pay taxes on these dividends. This is commonly known as double taxation. An advantage is that the shareholders are only responsible for the company up to the amount of their personal investment. They may lose all of their stock in a corporation if it goes belly up, but they will not lose their homes or other personal belongings. The S corporation is very similar to the C corporation. Like the C, it is owned by shareholders who do not bear personal liability for all of the losses of the corporation. The same filing requirements and formal rules apply to both types of corporations. However, There are several differences between these two. A major difference and advantage of the S corporation is that its shareholders will not be taxed twice for the company's profits. All profits are passed through the shareholders' individual tax statements. Another difference is that the S corporation cannot have more than 75 shareholders, while the C corporation can have an unlimited number of shareholders. For this reason, larger corporations are C corporations. The final option we will be discussing is a limited liability company, or LLC. The LLC is not a corporation. It is a distinct form of business ownership that combines features of the corporation with features of the partnership or sole proprietorship. Forming an LLC is similar to forming a corporation. Articles of organization must be prepared and filed, and fees must be paid. Florida charges a $125 filing fee to form this type of business. An LLC is like a corporation because it provides liability protection for its owners. It is like a sole proprietorship, partnership, or S corporation because it protects its owners from double taxation. Profits are accounted for on the individual owner's income tax returns. The LLC owners may choose to operate the LLC like a corporation and elect managers to run it, or they may choose to operate like a partnership and manage the company themselves. Even a single person can operate an LLC. When considering an LLC, the major advantages include the owner's liability is limited and there is no double taxation. The con side is it is somewhat complex and in some states expensive to form an LLC. When you're faced with the decision to choose the right type of business form for your company, remember it will depend on a company and owner's particular circumstances. When you are trying to select the best form for your business, it is always advisable to consult an attorney before you decide.